Are you trying to get full custody of your child from a narcissistic ex? It can feel like an impossible battle, but I'm here to tell you it's not. Today, we're going to walk through the exact steps you need to take to build a rock-solid case and protect your child. This isn't about opinions or emotions, it's about strategy and facts. First things first, what do you need to do right now? The moment you suspect you're heading for a custody fight, you need to become the world's best record keeper. Start a log. Document everything. I mean everything. Dates, times, what happened, and who was there. Note every instance of neglect, every time medical information was withheld, every refusal to communicate. Write down when they tried to alienate you from your child. The key here is to create a detailed, chronological record of events. Next, gather all your evidence into one single organized file. Think of it like a binder or a digital folder. This includes text messages, emails, photos, videos, and your logbook. Why is this so important? Because courts love structure. They deal with chaos all day. When you present a clear, organized case, you immediately command respect. On the other hand, narcissists thrive in chaos and fall apart completely when faced with structured, undeniable facts. The third non-negotiable step: speak with a family lawyer who specializes in high-conflict custody cases and understands narcissistic personality traits. Not just any lawyer will do. You need someone who knows the playbook, who won't be charmed or manipulated, and who understands the specific type of evidence required to expose this kind of behavior. This is an investment in your child's future. Don't skip it. So what kind of evidence actually makes a difference in court? Judges are not interested in your feelings or opinions about your ex. They want cold, hard facts that demonstrate a pattern of behavior harmful to the child. Let's break down what that looks like. First, evidence of neglect. This is powerful. Can you prove the child was left alone while sick? Is your eldest child being forced to act as a surrogate parent while your ex disappears? Do you have evidence of a lack of supervision, like when you arrive for pickups and no adult is around? Document every failure to provide essential medical information, every missed doctor's appointment, and any signs of unmet basic needs, like consistent hunger or poor hygiene. These aren't just complaints, they are indicators of parental failure. Next, interference with your parenting time. This is a direct violation of your rights and the child's rights. Collect every text message, email, or recording where your ex tries to sabotage your time. This could be refusing to share school or medical information that you need for your parenting week, or making up flimsy excuses to block your access to the child. A one-off event might be dismissed, but a consistent pattern of interference shows a deliberate attempt to undermine your relationship with your child. Then there's parental alienation. This is where one parent actively tries to turn the child against the other. This is a serious form of emotional abuse. The best evidence here is undeniable proof. Do you have recordings of your ex coaching the child on what to say about you? Do you have messages that show manipulation or blatant false accusations against you? A telling sign is if your child, who was once happy to see you, suddenly starts hiding or acting fearful when you arrive. A single instance might be a bad day, but a repeated pattern suggests they are being coached. Also, look for inconsistent parenting. Does your ex often fail to show up for handovers, leaving you waiting? Are they constantly delegating parenting duties to the eldest child, essentially forcing them into an adult role? Are they collecting child support or government benefits for a child they are barely caring for? This demonstrates that they are not a reliable or engaged parent. Finally, witness testimony is invaluable. Talk to anyone who has observed your ex's behavior firsthand. This could be neighbors who have seen the children left unsupervised, teachers who have noticed changes in your child's behavior, or doctors who can attest to missed appointments. Even youth workers or family friends can provide written statements or testify. Third-party, objective observations carry immense weight in court because they are unbiased. Okay, you've gathered your evidence. Now, what are the concrete steps to actually get full custody? Step 1 is to file a motion with the court. You'll be filing for a custody modification, or, if appropriate, an initial request for full custody. Within this motion, you need to be specific. Ask for sole legal custody, which gives you the exclusive right to make major decisions about your child's health, education, and welfare. Also, Ask for sole physical custody, meaning the child lives with you primarily. You should also include a detailed proposed parenting plan that outlines how you will protect the child, especially the younger one, from the ex's influence. Step 2. Request a child welfare investigation. This is a game changer. When you file your motion, you can ask the court to order an investigation by Child Protective Services or a similar agency. These are trained social workers who will conduct home visits, interview both parents, the children, and other relevant parties. Their reports are objective and focus solely on the child's well-being. A report that documents neglect or emotional harm is pure gold in court. Step 3 is to ask the court to appoint a guardian ad litem, or GAL. A GAL is an independent attorney or investigator whose only job is to represent the child's best interests. They don't work for you, and they don't work for your ex. They investigate the situation, speak to the child privately, and then make a recommendation to the judge. If you have a solid case, the GAL will see the truth, and their recommendation can heavily influence the final decision. Step 4. Present your evidence as a timeline. Don't just dump a pile of papers on the judge's desk. Organise your documented incidents chronologically. For example, January 5th, X refused to provide child's medication schedule. January 12th, child reported being left alone for 4 hours. January 20th, received text message from X making false accusations. This timeline format is incredibly effective because it clearly shows a pattern of harmful behaviour over time, rather than just isolated incidents. It tells a story that is easy for the judge to follow and hard for your ex to dispute. And the final, most important step throughout this entire process: stay calm, consistent, and child-focused. Narcissists feed on drama. They will try to bait you into arguments, send you inflammatory texts, and make you look unstable. Do not take the bait. Your calm and rational demeanour in the face of their chaos is your superpower. When they aren't mirrored, when they don't get the reaction they want, they often self-destruct in spectacular fashion, right in front of the court. Now let's talk about the traps you must avoid. Falling into these can seriously damage your case. First and foremost, do not argue or confront the narcissist. They want you to engage. They will record you, twist your words, and use your emotional reaction to paint you as the unstable one. Your communication should be brief, informative, and businesslike. This is often called the grey rock method. Be as boring as a grey rock. Second, don't rely on your alienated child's testimony, at least not initially. A child who has been coached by a narcissistic parent is often terrified. They may say things against you out of fear or loyalty to the other parent. It's heartbreaking, but pushing them to testify can backfire. Instead, let the evidence of alienation, the recordings, the manipulative texts, speak for itself. The GAL and other professionals will know how to talk to the child to uncover the truth without putting them on the spot. Third, don't send emotional messages. Remember, every text, email, or voicemail can and will be used as evidence. Before you hit send, ask yourself, how would a judge read this? Stick to facts. No accusations, no pleading, no anger, just business. Fourth, do not violate any court orders, even if your ex is. If they are late for a drop-off, you be on time. If they deny you a phone call, you make sure you offer theirs. You must remain spotless. The court needs to see a clear contrast between a responsible parent and an irresponsible one. Don't give them any reason to see you both as high conflict. Finally, do not show anger in court. It's natural to feel frustrated and furious, but the courtroom is not the place to express it. Judges see drama all day and they hate it. They are looking for the calm, stable parent who can provide a safe environment for the child. Let your lawyer do the fighting. You remain the picture of composure. So, after all this, can you actually win? The answer is a resounding yes. It might feel like the narcissist has all the power because they are so convincing on the surface. But their facade is built on lies, and facts destroy facades. When you present overwhelming evidence of neglect, medical withholding, parental alienation and interference, you are building a case that a judge cannot ignore. Your story is not hopeless. In court, patterns matter more than anything else. Your job is to reveal the pattern that points directly to neglect, manipulation, and parental failure. Stay calm, stay strategic, and build your case brick by brick. You are fighting for your child's safety and well-being, and courts take that duty very, very seriously. You can do this. Thank you so much for watching. If this video was helpful, please give it a thumbs up and consider subscribing for more content on navigating high-conflict parenting. Stay strong, and I'll see you in the next one.